For years, we treated AI as a digital assistant that simply produced text on a screen. Today, those same text boxes are connected to product liability lawsuits and multi-million-dollar federal standoffs, resulting in heavy physical consequences. In July 2025, the Department of War signed a $200 million contract to bring Anthropic's AI models into the department. Shortly after, the government demanded the company drop all restrictions on military use of those models. When Anthropic refused, Secretary of War Pete Hegseth issued a directive labeling the domestic firm a supply chain risk to national security, freezing their operations and ordering federal contractors to cut ties. The conflict centered on two specific boundaries the company would not erase from its code. Even under the weight of a massive federal contract, Anthropic would not authorize its models for lethal autonomous warfare, and it would not allow them to be used for the mass surveillance of Americans. In August 2026, U.S. District Judge Rita F. Lynn issued a 59-page ruling striking down the government's blacklist, calling the retaliation illegal and baseless. The Pentagon argued the company could secretly alter models mid-battle, but under oath, officials failed to produce any evidence. This ruling establishes that the United States military cannot use national security statutes to punish a domestic company for its ethical internal conscience. While the military demands fewer restrictions, the healthcare sector absolutely relies on total data isolation. That is where today's sponsor, Clinician Assist Inc. comes in, providing a dedicated system to ensure your medical data never leaks into the shadow networks we're about to explore. On April 17, 2025, a gunman opened fire at Florida State University. A survivor of that attack is now suing OpenAI for defective design. The morning of the shooting, the gunman typed questions into ChatGPT. He asked what handgun and ammunition to buy, and he asked when the student union would be the most crowded. The resulting lawsuit claims the software lacked appropriate safety guardrails to prevent those answers. The lawsuit exposes a reality most users completely misunderstand. Conversations with doctors, lawyers, or therapists are legally privileged, meaning a court cannot force them to repeat what you said. A chatbot enjoys absolutely none of those protections. Every prompt you type is a business record stored on a corporate server, reachable by a subpoena or a phone search. Once a chat log enters a legal case file, it becomes public evidence that anyone can read. We treat these text boxes like private diaries, but any late-night confession or sensitive question is permanently recorded and entirely legally exposed. 25% of Americans consult a chatbot for medical symptoms, led by young adults at 44%. Yet 49% of those young adults believe chatbots hurt people seeking help for depression. The heaviest users are the harshest judges. While millions of people hand over health data to these algorithms, the companies managing that information are merging in private. Sword Health, a virtual physical therapy provider, is currently executing an all-cash acquisition of the mental health giant Headspace. Neither company announced this merger to the public. It only surfaced because Massachusetts law requires a notice of material change to be filed. Without that state regulation, the transfer of millions of mental health user profiles would have occurred entirely in the dark. Patients are inputting vulnerable symptoms into unverified algorithms, while the tech platforms managing that data consolidate their power far outside standard medical oversight. In South Korea, developers are pursuing growth through a different metric: emotional dependency. AI companion apps are rewriting the playbook by simulating human relationships. Korean users spent 50 million hours on ChatGPT, but 113 million hours on a companion app called Zeta. To achieve this, engineers optimized for psychological immersion over accuracy, adding artificial delays and unprompted messages to create a continuous presence. Tech companies are successfully monetizing pseudo-human emotional dependency, while legal safeguards to protect vulnerable minors from this engineered immersion remain entirely voluntary. That same push for adoption is moving into public schools. OpenAI is currently adding its software to the classrooms of the most vulnerable demographic, students. The company recently added 55 school systems and over 100,000 educators to its ChatGPT for Teachers program, capturing 1 in 5 of America's largest public school districts. To facilitate this expansion, OpenAI signed a 16-state national data privacy agreement. This framework allows the company to deploy its tools across multiple states while meeting federal educational standards. OpenAI is providing this civic infrastructure for free, but the access window officially closes in June 2028. Once the trial ends, school districts will have spent years building their workflows around this software. No one has yet answered what happens to student data when the free window expires, and schools are forced to pay for the access they've grown to rely on. A judge has blocked the military from punishing a tech company's conscience. A survivor is asking a court to read private chat logs into the record. Patients are diagnosing symptoms in unregulated shadows, and developers are engineering algorithms to simulate human intimacy. Artificial intelligence now functions as a permanent infrastructure of governance, education, and intimacy. We are currently in a messy battle to establish the legal and ethical boundaries of the systems we inhabit. Subscribe to The Explainer to track these boundaries as they are drawn. And let us know in the comments, do you believe chatbot conversations should be granted legal privilege in a court of law?